Mr. Chairman and committee members, my name is Zach Whiting. I'm a policy director and senior fellow at the Texas Public Policy Foundation. The foundation appreciates the opportunity to testify today. Artificial intelligence is a top 10 policy priority for the foundation going into the next session, and we look forward to supporting the legislature's efforts to enact meaningful AI policy. We have, I feel like every time I see you, Mr. Chairman, and your staff, I say we have a forthcoming research paper, and we still have a forthcoming research paper.
We have a forthcoming bill. So
we have, everything is forthcoming. But nonetheless, that research paper, I'm hopeful that it'll be published this month. It's a very comprehensive research paper. My colleague David and I primarily wrote it. Be about 150 pages, go through the history of AI, its sort of technological intricacies, some of the regulatory approaches at the local, state, federal, and international levels, some policy prescriptions, which are primarily included in the written testimony that we provided, and the like. So big picture, looking at what are some of the principles that should guide AI policy. And one of the points I frequently make is I'll talk about principles and then I'll say, principles, can't guide. You have to have concrete language and definitions on the four corners of a bill. So we also have a glossary in our paper that will hopefully assist with that. So big picture principles, human dignity. That has to be the cornerstone of everything. The professor that testified at the University of St. Thomas, I think, covered the human dignity component of that very well. Our guiding principle is that technology should serve humanity, not the other way around. And so some of the questions, the moral, the political and the legal questions that go into the design and use of artificial intelligence, as people have testified here and in other settings, they present critical challenges to the state, to the nation, and even humanity, and that's not hyperbole. So proceeding with caution and humility, I think, is very important. Using it to augment human efforts, that's good. Using it or having it be used in a way to surpass, replace, or defeat humanity is bad. That's the human dignity component. Second, privacy. It's been talked through much during this hearing. A lot of the work you're doing on AI is a continuation of the great data privacy work that you guys have done in previous sessions. So data privacy, cybersecurity protections, those need to be the keystone of any AI bill that you consider. Things that we've talked about as well, putting additional protections on sensitive information, which has been a topic of many of my colleagues who have testified here, as well as additional data protections on minors, which has again been very consonant with the data privacy and kids online safety bills that you all have done last year. I think another important piece to consider in this is a sort of a digital Bill of Rights-like approach. Again, similar to what y'all did with Texas Data Privacy Security Act last session, rights to know, access, correct, delete, and opt out of data being used for training purposes. Transparency, I think, is a third principle to talk about. That is the metric by which the consumer protections need to be measured. Texans deserve to know when they're interacting with AI, full stop. I think notice is the absolute bare minimum of what we should do. And making that notice, evident to the user, conspicuous to the user. In the data privacy context, we've written about this in a previous research paper, that in order to exercise the full, strength of the data privacy protections that a site may offer, it's somewhere in the ballpark of a 10-to-1 ratio. Is you have to do 10 clicks in order to exercise the strongest data protections versus one click to just accept, what they do. So again, those things go to the transparency piece, letting people know they're dealing with AI, period. Fourth, accountability and compliance. The goal of all this really should be compliance and not punishment. So it's not about punishing, companies that are developing AI tools, unless they're doing something very bad, then punish away. But making sure that, you make compliance streamlined, but carry a big enough stick to punish the bad actors. So again, used in other contexts, like in the data privacy context, creating a rebuttable presumption that if you're complying with, industry standards or something like that, that you are, complying with the requirements of the law, a rebuttable presumption. Nonetheless, things like, the NIST standards that are out there, the other voluntary, standards that the, top 16 companies or whatever are working with the White House on. A cure process, I think, is something to consider. Again, if you want people to comply with the law, give them a chance to, cure any of their defects before just default punishment. And again, the degree to which, auditing and reporting is required. Others have testified that, second, third, fourth, fifth level audits is, burdensome. That might be, but there still needs to be, again, some kind of auditing process and reporting process. And then another question that I think is brought up, I think it goes, Representative Leach, to your questions with the gentleman from the broadcasters, is how do you consider those questions of applicability, liability, enforcement? So in the context of AI, it's distinguishing between the developers, the deployers, and end users, maybe putting different obligations on them, asking, to whom they should apply. Should it be all businesses, some businesses, big businesses, but not small businesses? Certain other categories of businesses that work in, the healthcare space or something like that. Not prescribing that as an idea, but just as an example. And then the other question, again, this I think will be a big point of debate, but is how do you enforce it? Now, primarily in a lot of the technology bills that y'all have done lately, it's been streamlined through the Attorney General's office, through the deceptive trade practices regime. I think that's probably a good way to go. Again, this session, the office has set up a sort of data privacy, division. So they're investing the resources and the manpower to do that. If I may inject, I don't know if I'm testifying on behalf of myself, but if I may take on my other hat, Representative Leach, you brought up kind of the question of, who's harmed and what's the remedy. The enforcement through the Attorney General's office, through the deceptive trade practice regime, that's nice, streamlined. The people who are regulated, they get that. The question is, if someone is harmed by a malicious act, by an AI product, what is the remedy for that person? And that's something that I personally am conflicted on, because I would much rather see the person harmed be remedied than, frankly, the state and their coffers. But nonetheless, those are the challenging public policy questions that lawmakers have to address. And then, Mr. Chairman, kind of to your point is, how do you fit all these principles in? Where do they fall in? And I think, as you've alluded to in addressing some of the other witnesses, a risk-based regulatory framework, I think, makes the most sense. And you look at what are the potential for harms, what is the severity of the harm, and you apportion things accordingly. The common model that was used in Colorado and the European Union, for example, contemplates high-risk activities and puts additional requirements on that. The EU model contemplates unacceptable use cases, and I think that Texas should absolutely consider some of those, some of which were asked of the last witness, and for which there's a list. And so, looking at, again, guardrails on high-risk use cases, prohibiting unacceptable use cases, encouraging developers and deployers to adhere to those industry standards, maybe even incentivizing them again with that rebuttable presumption, I think is good. And it has been alluded, just to illuminate the risk-based framework. We've talked about it before, but essentially a high-risk decision is when an AI system makes a consequential decision about the provision of educational, employment, financial, government, healthcare, housing, insurance, or legal services. So when it's used to make or substantially make that question, it raises, concerns, and maybe some additional safeguards are needed there. And then finally would be some use cases that just aren't allowed. Things like manipulating human behavior, untargeted, unwarranted facial recognition, emotional recognition in schools and the workplace, social credit, was asked about earlier to, I believe, one of the health insurance witnesses, and things like the creation of child sex abuse material. And to the point, that was kind of asked of the last witness from UTMB is, are there some things that we should be studying or creating models for at all? And so you balance the need and the desire of the first witness to, create entertaining, interesting, artistic products or things that are, otherwise protected in the satirical space, versus apps like, as I've testified before, that do nudification of children. Should there be any model at all that is created that is allowed to do that? I think the answer is unequivocally no. And it's disgusting that, again, if it's data in, data out, there's data going into that's training you to say, here's what a nude child should look like. It's disgusting. It shouldn't be allowed. And I'd be happy to have a conversation as a dad, as a former lawmaker, as a policy advocate with anyone that thinks that we should. I want to just illuminate, and probably should just let y'all ask questions since I'm probably keeping y'all from lunch. But a couple other points that came up that I wanted to mention. The use of AI in the courts, it probably would have been helpful. I'm casting no aspersions, but to have a perspective of the bar or someone that could speak to that. But one of the issues that we do talk about in the paper is, how should AI be used in the justice system broadly? And so we say, on the one hand, a beneficial use case could, for example, helping a self-represented litigant navigate the system. How do I even file a small claims case? Or is this the right court to go to? Where do I find information? Those kinds of things. AI, can be helpful for that. Then you asked, or then you consider the folks that are, licensed and practitioners. Should they be using AI, for example, to, write briefs or submit, items to the court? That's a concern. It goes into those broader, professional questions that were asked earlier in the physicians and healthcare providers. Unfortunately, we've seen examples where lawyers have submitted briefs with fake citations to fake cases in very consequential cases as well. So that's a concern. And then thinking big picture, about the justice system, is this a type of question that, for example, notwithstanding any sort of separation of powers questions, is it something that, one body, an elected body, should outline and prescribe a sort of the rules of the road for the judicial system? Or is it something that we should decide on a case-by-case basis, judge-by-judge basis, circuit-by-circuit basis? We sort of want to say, yes, we want the judiciary to sort of work those questions out. But when we have cases like a Washington state judge who denied the admissibility of AI-enhanced video in a triple murder case, there's some real jeopardy at play. I'm going to say that I doubt Washington state is a death penalty state, but nonetheless, life in prison is a real liberty question. So those are the types of questions I think would be important for lawmakers to consider on the front end. And if, the bar decides to participate in the conversations, that would probably be helpful. And then the last piece, and then I'll be happy to answer any questions, is a great discussion with the last panel on AI and healthcare use, and I think recognizing that more likely than not, at least under the other risk-based models, that is something that would fall under, a high-risk category. And so again, having those additional protections and safeguards would be in place. Going to the data privacy question and the sort of the ownership of your health information. I believe there was a bill for that last session, Representative Capriglione, that you had. So I think that's an important conversation to have, is who owns that data. I think it should be, the patient and the healthcare, provider, the hospital system, whoever are a custodian. The bill contemplates, being able to buy that data, all those good things. And notice and consent, for AI to be used in frankly, any sort of diagnostic context. I think that's pretty standard. I mean, you go in, you reinitial everything. You go in there, I agree to this and HIPAA that, and oh, by the way, we might use AI. Would you be interested in that? Sure, sign off on it. Notice and consent, I don't think it's unreasonable. And again, if it's in the informed consent, the judgment of the patient that this tool would be beneficial for their treatment and their course of care, I think is good. One of the gentlemen spoke in sort of in the emergent setting that you may not be able to make these decisions, on the fly. Again, there can be exceptions for that, but I think the general rule being notice and consent, and particularly in the health context, and informed consent, and making sure that whatever the state of the law is with HIPAA and everything else, the state of Texas can still, add a layer on top of that to additionally safeguard patient data. So a lot of rambling, but happy to answer any questions or point you to our forthcoming research paper, because if I don't know it,